The legal structures around surrogacy underwent a change last April, and attorney Adele van Walt, who rejoins us, is well versed in how these changes affect the legal process now. Adele, tell me about that. What's changed?
Okay, before last year, the 1st of April 2010, the process from a legal perspective was very informal. There was no requirement that the surrogacy agreement had to be even in writing. So sometimes people had a verbal agreement between them, other times they had it in writing. After the 1st of April, we've got a bit of red tape. The specific act regulating this is saying that it should be in writing. There should be specific requirements. I can maybe just name a few.
Yes.
The surrogate mother has to have at least one child of her own.
Why is that?
That is the risk, the risk with the emotional side of it, that the surrogate mother might decide to keep the child, is definitely going to be minimized if she has had at least one pregnancy and child of her own.
If a surrogate mother should decide halfway through the pregnancy that she doesn't want to give up the child, what happens then?
Okay. Maybe I should answer and say before the act and after the act how it changed.
Okay.
Before the act, this was the biggest concern for all the parties really involved. The surrogate was always concerned that the parents-to-be might decide not to take the child, especially if there's some deformity of some kind. On the other hand, the intending parents or the to-be parents were always concerned that the surrogate might decide not to hand over the child. So it was always these two risks.
A grey area.
Yes. Now after the act, with the red tape in place, before you can even start with the in vitro fertilization, you have to go through this court procedure with the screening, the emotional side, the medical side, and then of course the expectations from a legal perspective, what needs to be transparent also in the legal procedure and in the documentation. This gives certainty for all the parties involved, because now with this court order that you have to obtain before the in vitro fertilization can take place, you know for certain that if it's the genetic material, the genetic material that's a sperm and the egg of the parents-to-be, that court order will say that any child or children born from that agreement will be the child or children from these parents.
So if the mum and dad who provide the sperm and the egg, if they then are the legal parents, no matter that the surrogate carries the baby, is that correct?
That's right. So even if it is, the surrogate mother decides to change her mind, you've got a court order saying that it's your child.
What if it's a donor egg?
Okay, even so, if it's a donor egg or donor sperm, the Act still says, as long as if it is the genetic material of at least one of the two parents. So if it's then a parent to be being single, it must be the genetic material of that parent.
What if it's the surrogate's egg?
Okay, the legislation is trying to stay away from this because that's your highest risk. The legislation is saying that if the surrogate mother is using her own genetic material, she will have a cooling off period of 60 days after birth to decide whether she's keeping the child. So that is definitely an inherent risk.